So maybe Amy, you could start us off with the legal side of it. What does that Supreme Court decision even mean? Like, what is that about?
So Roe v. Wade was a decision made by the U.S. Supreme Court in 1973. It found that a person has a right to elect an abortion before the viability of a fetus. They found that the right was based on the right to privacy, which is an unenumerated right found in the Due Process Clause of the 14th Amendment of the U.S. Constitution. And when we say that it's in the Due Process Clause, it's something called substantive due process, which is kind of something pretty squishy when we talk about legal rights. And that's one of the reasons it's a controversial decision among some of the other decisions that were made around the same time by the Supreme Court. Prior to this, whether or not abortions were legal were left for individual states to decide. And
you said squishy. By squishy, you mean?
Squishy, I mean, so one of the reasons people argue it's squishy is it's a non-enumerated right. So it's not clearly stated, but then again, in the Constitution, it says that not all of the rights are enumerated. That's part of why the founding fathers didn't want a Bill of Rights, because they didn't want the government to come back and say, well, these are the only rights that you have. And so in the Bill of Rights, there is a provision that says there are other unenumerated rights, which gets us into some of the, when we talk about Dobbs v. Jackson, we'll talk about how the Supreme Court is treating that.
Okay.
But at the time of Roe v. Wade, legal scholars and court observers on all sides, so both in favor of making this a right and those against it, thought that there were weaknesses with the case. One, because it was this substantive due process. And second, that it was based on a right to privacy and not really about a woman's right to choose or autonomy or human rights at all. In fact, Ruth Bader Ginsburg, who's kind of the feminist icon in general, for sure in the legal field. And I mean, she's not just an icon, she actually made very real legal contributions to these issues. She had issues with Roe v. Wade. She thought it happened too fast, too soon, and that it led to the backlash that kind of plagued our country for the last 49 years and continues to today. So fast forward to 1992, there was a change in the Supreme Court's makeup by then. They thought that perhaps now was the time to challenge Roe v. Wade and get it overturned, those who were in favor of overturning that Supreme Court decision. And so what ended up happening is an unexpected coalition on the court formed, and they affirmed the central holding of Roe v. Wade, which basically said that it's a privacy right. You cannot abridge a person's right to make that decision before viability. You cannot put a substantial burden, I think is the language that they used in that case. But they abandoned the original framework in Roe v. Wade about what regulation could happen when. The case did open the door as a result for more regulation of abortion, and some would argue paved the way for this decision ultimately. But a large portion of the decision referred to the importance of the legal concept of stare decisis, which is the reliance on prior decisions of the court because the public relies on them. So for stability in the law, it's important to respect prior decisions in the law. So we get to Dobbs v. Jackson, which was the case decided that last week or almost last week of June of this year. So just about 3 weeks ago. It overruled explicitly Roe v. Wade as well as Casey, and it indicated that the federal constitution does not hold a right to abortion because it is not deeply rooted in the nation's history. So the court denies that they're getting rid of denies that they are going after all unenumerated rights, but they say an unenumerated right needs to be deeply rooted in the nation's history. And this is very specific to the legal view of the majority of the justices on the court. There's nothing in law that says it has to be that. That's what they say it should be, though, based on the way that they interpret law. So as a result, it returns to the question of whether or not abortion should be legal to the states. So technically, it doesn't outlaw abortion, the decision itself, but it throws it back to the states. So each of the 50 states, District of Columbia, can decide what to do. Justice Alito, in his majority opinion, denies that it extends to other decisions that are also rooted in the right to privacy, such as contraception, banning laws on sodomy, and gay marriage. But Justice Thomas believes that those decisions should also be revisited and presumably overturned. And the dissenting justices who disagreed with this decision argue that all of these rights are intertwined, so they either all stand together or they all fall together.
So You talked about this stare decisis, that, so what this does is it says that it kind of puts in peril any decisions that were made prior to, prior to now, because
Yeah.
previously you could kind of depend on, well, the Supreme Court already decided this, so a decision that's made would have to kind of align with it, at least to a large extent, but this kind of puts in jeopardy.
Yes, and I guess in theory, the decision doesn't do away with the doctrine of stare decisis. On the other hand, they said these cases were wrongly decided, and stare decisis does not constrain us from overturning them. And it's interesting because stare decisis is a form of judicial restraint. It constrains judges to keep the status quo, when a decision has been made. The judges who, again, are relying on these concepts like an unenumerated right has to be deeply rooted in the nation's history, tend to follow the legal theory of originalism, and they claim originalism is a judicial restraint on and of itself, but it can also be used in different ways. And so it's interesting for those who would like to claim that we shouldn't be activists, we're not legislating from the bench. We believe in judicial restraint and constraining ourselves to our role, in a way exceeded something that was a judicial restraint by ignoring stare decisis and making this decision. Obviously, people have opinions on both stare decisis and originalism and a whole bunch of other things on what's right and what's wrong, but that's kind of the different issues that are at play legally here.
Okay. Just another clarification question. So you talked about, this decision specifically deals with abortion, but not contraception.
Correct. People are afraid contraception could be next. So basically, when these cases started, it started with a contraception case. It started with the right of married people to be able to get contraception. Then what was kind of bootstrapped next was the Supreme Court decided, well, you can't discriminate between married people and unmarried people. So if married people have the right to contraception, all people need to have the right to contraception. So it's kind of the decisions build one on top of the other. So those two happened first, abortion came next. And so the fear is if the top one got knocked down, are the other ones that were underneath it going to get knocked down too? Again, Justice Alito says, no, that you're worrying for nothing, but Justice Thomas says we should go back and reconsider these.